relating to arrests in India is provided under the Code of Criminal Procedure 1973, Chapter 5 from Section 41 to 60A. In this video, we will discuss Supreme Court guidelines in Arnesh Kumar case. The quick pointers of the case are: case name Arnesh Kumar vs. State of Bihar and others, date of judgment 2nd July 2014, bench Honorable Justice Chandramouli Prasad and Honorable Justice Pinaki Chandra Ghosh. Statutes referred in this case are Section 498A of IPC, Section 4 of the Dowry Prohibition Act 1961, Sections 41, 41A, 57, 167 and 438 of CRPC, Article 22, Part 2 of Constitution of India. In Arnesh Kumar vs. State of Bihar, having apprehensions related to arrest under Section 498A of the Indian Penal Code and Section 4 of the Dowry Prohibition Act, the court ordered that no arrests will be made automatically in case under Section 498A. The facts of the case are: this case is a landmark case on two folds. Firstly, on misuse of Section 498A of IPC, and secondly, on putting further checks and balance on power of police to arrest without warrant. The marriage between Arnesh Kumar and Shweta Kiran was solemnized on 1st of July 2007. Shweta Kiran alleged before the court that her mother-in-law and father-in-law demanded rupees 8 lakhs, a Maruti car, an air conditioner, television set, etc. And when this fact was brought to the Arnesh Kumar's notice, he supported his mother and threatened to marry another woman. Further, she also alleged that she was driven out of her matrimonial home due to non-fulfillment of the demand of dowry. Arnesh Kumar denied these allegations and preferred an application for anticipatory bail, which was earlier rejected by the learned Sessions Judge and thereafter by the High Court. Hence, Arnesh Kumar has moved to Supreme Court by the way of special leave petition. The issue that was involved in this particular case was the grant of anticipatory bail. The anticipatory bail was not granted by the High Court. The case further deals with some more important issues, that is, right of accused person before and after arrest. Second, what are remedies that are left to a person when there is a misuse of Section 498A of the IPC by women? Third, whether it is necessary for a police officer to arrest a person against a complaint if such person is suspected to commit a cognizable offense. Number 4, whether the appellant should be granted anticipatory bail. The Supreme Court granted provisional bail to the appellant on certain conditions. The Apex Court said that Section 498A is a cognizable and non-bailable offense, has lent in a dubious place of pride amongst the provisions that are used as weapons rather than shield by disgruntled wives. The simplest way to harass is to get the husband and his relatives arrested under this provision. The Apex Court gave some mandatory directions for police to be followed before arresting a person to avoid unnecessary arrest of accused. The court, further elucidating the role of magistrates and police officers in making arrests, laid the following guidelines. Number 1, state governments had to instruct police officers to not directly arrest person when registered with offense under Section 498A. It may be necessary when it falls under Section 41 of the CRPC. Number 2, checklist under Section 41 Part 1B subsection 2 need to be given to all police officers. Number 3, While producing accused before magistrate for further detention, this checklist to be duly filled and also having the reason and material necessary for making the arrest. Number 4. Relying on this report and only after recording the reason for arrest and on magistrate's satisfaction will further detention to be granted. Number 5. If not arresting accused, this decision be forwarded to magistrate within 2 weeks from when case instituted with copy of magistrate extended by the superintendent of police of the district for the reason to be recorded in writing. Number 6. Notice of appearance as per section 41A CRPC is to be served to accused within 2 weeks from when case instituted and which may be extended by the superintendent of police after recording the reason in writing. Number 7. If directions not complied with, police officers liable for contempt of court before the High Court having jurisdiction. Number 8. If detention is authorized by judicial magistrate without recording reasons, they be liable for departmental proceedings by the High Court. Number 9. Further, these directions were to not only apply to cases under Section 498A or Section 4 of the Dowry Prohibition Act, but also all such cases where offences are punishable with 7 years or lesser imprisonment irrespective of the fine. Number 10. The copy of this order was to be forwarded to all chief secretaries and DGPs of all the states and union territories as well as the Registrar General of all high courts in order to ensure compliance with. Recent case. On 8th of January 2022, the Delhi High Court sentenced a police officer to 1 day imprisonment as he had arrested a man in defiance of the guidelines laid by the Supreme Court in Arnesh Kumar versus State of Bihar. The man arrested was detained for 11 days before bail could be granted to him. The case against the man was of criminal breach of trust having a maximum sentence of 3 years, and hence notice of appearance was needed to be served in order to arrest, and if exceptional circumstances pleaded, reasons for the same were to be recorded. Justice Nizami Waziri said the requisite notice was not served upon the petitioner. There were mere allegations of criminal breach of trust against the petitioner, which entailed a maximum sentence of 3 years. It did not warrant the arrest of a person in the manner in which it was done. The police officer even tendered an apology, however, the court refused to accept the same and imposed a fine of 2,000 as well as nominal cost of rupees 15,000 to be paid to the petitioner.